because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done. Court does call the case. People of State of Michigan versus Julie Van. Oh.
Good afternoon, Your Honor. Warren Green on behalf of Ms. Vongfachan, State Champ.
Julie Vongfachan.
Your Honor, today's for a motion hearing before the court is the defendant's motion to modify bond. Our motion is based on MCR 6.106. Your Honor, when we filed this motion, it wasn't our intent to try to distort the law or the facts to make an argument that somehow the court is bound to reduce her bond or grant our request. I think we know what the facts are leading up to this, and we know what the law is on whether the court can deny bond in such an instance. What we did was we laid out what we felt was a full and fair account of the actions leading up to this. And I don't think the people denied any of those actions leading up to this, just from a purely scheduling standpoint and from the standpoint of what I wanted to draw the court's attention to was that prior to Ms. Vongfachan's engagement with the criminal justice system in this case, she had previously engaged in behavioral health counseling. She was going to Apex Behavioral Health in Westland. I included the date in our motion. I mean, the address in our motion, but she was doing that until January of 2023. The way Ms. Vongfachan described that to me was, I think some of the behavior the court has seen through the bond violations it's heard is that Ms. Vongfachan, for some reason, when confronted with an issue in her life, at first blush, her first reaction is maybe to be dishonest or wiggle out of a situation. And I think she sought help with that exact behavior before. So our primary argument in support of the court granting our motion would be so that Ms. Vongfachan could re-engage with that kind of counseling. Of course, Ms. Vongfachan is fully aware of what her bond conditions were and will remain fully aware of what those are if the court will or cease using any intoxicating substance during the pendency of this case. I know she wants to seek reemployment for the job that she lost as a result of her actions. And I think she acknowledges that the delay and the turbulent bond release she's had so far have been her own doing. I think the time she spent in custody, she's had an opportunity to reflect and to think about how she wants to move forward. I think she wants to head in a positive manner towards resolving this case. And we would be asking the sentencing court to consider probation still. She knows that her bond violations are going to be considered by the sentencing court in determining.
Interesting how the defense frames this, pointing to counseling, reflection, and even acknowledging dishonesty as a core issue. On paper, it sounds like someone trying to turn their life around. But in court, words only go so far. Judges want proof, not just promises.
Tell me why I should let you out. Because, and there's a reason why I'm asking this, and so it's clear. And the facts of the case were relayed to me last hearing that we were on, or the alleged facts, I should say. I'm amazed that you took something that was a misdemeanor. I don't want to call it a simple misdemeanor, but a misdemeanor. And something that more than likely you would have never spent any time in jail on. And somehow on the date of that offense, parlayed that into a felony charge, or at least a high court misdemeanor charge. I don't even understand how that happened. But even after you have a case that you still wouldn't have spent any time in jail. And all you had to do is just follow the rules. That's all you had to do. And then somehow or another, you've now spent 3 weeks in jail on something that you would have spent no time on whatsoever. And I don't get it. I really don't. I say all of that to say, I feel like this is almost Groundhog Day. I bring you back the first time after the first week, gonna let you out, find out what you've done while you've been in jail, can't let you out. You spend that second week. Then I come back the second week, I let you out. Don't make it a day before you broke the bond conditions. Then next thing you know, next time you come back in, I got to throw you back in. And now here I am again. So it almost is that old saying, why should I repeat and do the same thing? Because that would be insanity on my part.
This is where the judge's frustration really spills out. Think about it, she started with a misdemeanor. Something that likely would have meant no jail time. But because she couldn't follow simple bond conditions, she turned it into weeks behind bars and a felony-level headache. The judge is basically saying, you're your own worst enemy. And honestly, he's not wrong.
The no contact order that was previously in place between my client and Mr. Gray.
No, and I'm not going to do that. I mean, and here's my reason. I'm not trying to be harsh about it, but that condition was in place from the get-go, right? And I think I indicated this to you, counsel, that when she came back and there were all those calls, I think I told you, because the communication regarding children was supposed to take place by text message, that I could even forgive a couple calls a day. I would just, without even knowing the content, I would just have to say she can't have that form of communication. But that's not even what happened. I mean, it's not even just about not following the rules. It's like she wants to play by her own rules. And I hope she understands this is what you get when you play by your own rules and they come in contravention to the court's rules. This is what you get.
This part is powerful, because the judge reads this heartfelt letter from the father of her kids, painting her as caring and different from the person in court. That contrast stings. It's like, which version is real? The supportive mother described in the letter, or the rule-breaking defendant standing in front of the judge?
You just made this a mess.
Your Honor, I think if she's on a Scram tether, she would refrain from partaking in any activities that would violate court's orders. She would, of course, still be subject to the drug testing requirement that was previously in place. I understand that environment.
But these things are promoted on the internet.
They are.
And one of the conditions I was going to have is that she can't appear vocal, oral, or otherwise on the internet. So how's she do what she was doing without doing that?
Ms. Fong-Fachan, is it possible for you to continue the business you're in without using Instagram or other social media as a way to promote your business?
I guess I just have to stop.
Okay. But is it possible for you to continue your promoting business without using social media?
That's how we promote the party. So,
Okay.
no.
Oh, dear God.
Are you able to seek other employment or
I'll
reemployment at
look
your
for another
previous
job.
job?
I'll look for
Okay.
another job.
Are you able to get in contact with your union representative of the union to see if there are ways that you can seek reemployment where you previously were working?
Possibly.
Frankly, for the most part, had you gone on social media after being in court, I could have cared less. But it's what you did when you went on.
Understand.
Well, what was in your head to call from Washington County Jail? Really, what?
I don't know.
What? No, you had to have. Don't tell me I don't know. What the heck were you thinking? Have you heard yourself on that podcast when you call from the jail?
I haven't. I heard one clip, but I haven't watched it.
Stupidest thing ever. I'm gonna tell you what, man. You better thank that man standing next to you. Because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done. And you just wouldn't see the light of day if it weren't for what arguments he was giving me. And at least the faith and hope that he has in you that you can just do the right thing. He's convinced me. I'm going to give you another shot. God help me if you had come back. God help you.
Here's where the judge lays it down. She didn't just bend the rules, she made her own. That's dangerous in the justice system. The judge makes it crystal clear, in this courtroom, you don't get to decide the rules. And if you try, you pay the price.
I'll reduce the defendant's bond to a $25,000 personal recognizance bond. I'm going to add all previous conditions that were originally set are reinstated. You understand that?
Yes, Your Honor. Thank you.
There's to be no appearance or vocal, oral, or otherwise on any social media platform. Defendant is to be placed on a Scram Tether prior to release. All right. Now let me explain something. You know about the Scram Tether?
I just know not to drink alcohol.
Now, if it comes back and you violate, so the reason I'm not just putting you on a sober link where you have to blow is because you don't know how to follow any rules. And that requires blowing 3 times a day. And I know darn well before the week is ended, you will not have done that because you just can't. At some point, you get so stubborn and you just say, I'm not going to blow into this thing. And then we're back here. So I'm trying to avoid that. If it comes back with anything, consumption of alcohol, I'll listen to you, but it's going to be really hard to convince me you didn't do it. Am I understood?
Yes.
Presses her on work, and it's almost sad. She admits she throws parties for income, but that directly clashes with her conditions. The irony is heavy, the very thing she relies on to make money could land her back in jail. Clip 6. This is the emotional peak. You can feel how close the judge is to giving up on her completely. If it weren't for your lawyer, you'd never see the light of day. That line hits hard. It shows the thin line between second chances and permanent consequences. Clip 7. In the end, she gets one more shot, but it's hanging by a thread. A tether, no social media, constant monitoring. The judge's tone says it all. I don't trust you, but I'll let your lawyer's faith in you carry the day. It's a warning, almost a final one.